Hi, I'm Dave Glatthorn. I'm an attorney in West Palm Beach. For the last 25 years, I've represented the people injured by the negligence of others. I want to talk to you today about a change that was made in the way medical benefits are administered under every policy of automobile insurance in the state of Florida. In the year 2012, the Florida legislature made substantial changes in sections providing for medical benefits, or the PIP sections of your automobile insurance policy. These changes take effect July 1, 2012, but they affect existing policies too. So just looking at your policy the way you have it now, even if it was written before July of 2012, will not tell you what your rights are. And the three significant changes that I want to talk to you about today are these. The first is this, that in order to preserve your rights to receive benefits, you have to seek initial care within 14 days of the accident. The second change has to do with a new definition that the Florida legislature has put into effect. Now remember, you're buying $10,000 worth of insurance. Insurance coverage benefits paid for medical benefits. But you only have rights to $2,500 unless certain designated types of medical providers will certify that you have an emergency medical condition. Now this is not a medical term. This is something that the Florida legislature devised. And it's a long definition, but basically it says that your condition has to be so severe that if you do not have medical attention, that your health is put in serious jeopardy. Now, you can't get that from a chiropractor because a chiropractor is not allowed to make that determination. And so we're not sure how the doctors are going to interpret this, but we do know that there are certain companies that have lists of doctors, and they will give incentives to their insureds if they go to these particular doctors. And the problem with that is, through sad experience, we know that if a doctor gets most of his business from one insurance company, then even if it's subconscious, he tends to favor that insurance company when there's a close question. And so this could mean the difference between you having access to $2,500 worth of medical care or $10,000 worth of medical care. The last change is now insurance companies have the explicit right to take an examination under oath if you got injured in an auto accident and are getting benefits under your PIP policy. Now, as a practical matter, that means that they can say, show up at this time in our offices on this date and give a statement under oath, and there's no limitation on how long that examination can go on. And the worst thing is that those statements that they can ask you about can be the basis of them denying coverage to you under the policy. If you're watching this video, you've got questions. For the last 25 years, we've been providing answers to people injured in motor vehicle crashes. Call us. We're here to help.